Okay, we are excited to start our first panel of the Wisconsin Law Review's 2020 Symposium. That panel is Critical Race Theory, Origins, Permutations, and Current Queries, and it is chaired by Professor Linda Greene. And so I will hand things off to Professor Greene. Thank you so much for putting this together.
Thank you. Hello and welcome to all participating. I want to give my thanks to the Wisconsin Law Review Symposium editors, Ms. Chase and Mr. Clegg, for organizing this event and for introducing me. I also want to thank Ms. Rebecca Rosenthal for her assistance in my preparation for this particular panel discussion. This panel is titled Critical Race Theory, Origins, Permutations, and Current Queries. Critical race theory emerged from a series of meetings in the 1970s and the 1980s, convened then by a handful of law professors, minority law professors, to address the apartheid in historically white American law schools. That apartheid had two dimensions. One, the exclusion of racial minorities from the legal academy as students and faculty. And two, the absence of pedagogy and scholarship directly related to the experience of racial minorities in the United States. In the early stages of those meetings, minority law professors addressed the exclusion of American racial minorities from the legal profession. But there was also another important concern. Professor Derek Bell summed it up in 1971. He said that the legal profession, the bar, and the American Association of Law Schools has been unresponsive to the needs and aspirations of Black people. After a series of meetings that took place in the 1980s, there were two significant gatherings here in Madison, Wisconsin, with the support of our law school. The first was the 1989 Critical Race Theory Conference, organized by Richard Delgado, Kimberly Crenshaw, and others. At this event, 24 participants discussed the foundations and antecedents of this emerging critical perspective, presented and critiqued draft articles, and began to develop the basic premises of critical race theory. A partial list of the participants includes Robin Barnes, John Calmore, Tanya Banks, Derek Bell, Richard Delgado, Mari Matsuda, Stephanie Phillips, Neil Gotanda, Anita Allen, Kendall Thomas, Kimberly Crenshaw, Pat Williams, Angela Harris, Harlan Dalton, and Richard Delgado. The second occurred in 1990. The 1990 Wisconsin Conference on Critical Race Theory, which I chaired, was the first open to the public discussion of critical race theory. Law scholars from around the country attended the conference, at which many of the papers presented have become a part of the critical race theory canon. In the 32 years since the 1989 Wisconsin Conference, the movement has morphed and evolved. Lat crit, Asian crit, LGBTQA queer theory, race and gender or intersectionality as we know it, poverty, immigration status, language, race, ethnicity, religion, education, disability, international human rights, literature, and medicine, all influenced by the evolving critical race theory movement. This centennial celebration provided the opportunity to celebrate critical race theory, and this panel will demonstrate the current and future relevance of its tenets. On today's panel, we have 6 fantastic scholars, all members of my extended collegial family. We have Mario Barnes, who is the Dean of the University of Washington School of Law. We have Dr. Angelica Guevara, who is a Hastie Fellow here at the law school. Professor Tanya Hernández of Fordham University Law School is here, as is Professor Emerita Gloria Ladson-Billings of the University of Wisconsin-Madison School of Education. Angela Awaki-Willig, Dean of the Boston University School of Law, is also present, as is Professor Kendall Thomas of the Columbia University School of Law, one of the original attendees at the first Critical Race Theory workshop. Each speaker will have 10 minutes to present, and at the end of all the speaker presentations, we will welcome your questions and your comments. It is such a pleasure to introduce Mario Barnes, who is the Tony Rimby Dean and a professor of law at the University of Washington School of Law. Previously, he was a professor of law and associate dean for research at the University of California, Irvine School of Law, and prior to Irvine was a professor at the University of Miami School of Law. He received a Master in Laws degree from the University of Wisconsin, where he was a William H. Hastie Fellow, and served as a commander in the Navy for 23 years. Now we know why he is dean. Today, Dean Barnes is presenting Still Defending the Notorious CRT, Old Claims, New Foes, and Pressing On Despite It All. Dean Barnes, thank you so much for joining us today.
So thank you, Professor Greene. Thank you to the University of Wisconsin. As I have said many times, I would not have become a law professor and certainly not a law dean without the influence of my experience in Wisconsin, without the resources the University of Wisconsin placed behind me. I am deeply grateful to Professor Greene, Professor Brito, our departed colleague, Professor Jones, who took an interest in supporting and berating me all at once in my time there. So thank you so much. I also want to thank the Law Review editors for including this important discussion among its celebration and for actually supporting CRT throughout the years. My first Law Review article, co-authored with the brilliant and amazing Angela Onwuachi-Willig, was published in the Wisconsin Law Review in 2005. Again, deeply grateful for their investment in young scholars and in CRT as a discipline. So it won't surprise anyone. I actually had a different paper essay planned for a long time until CRT was brought back into the spotlight recently with an attempt to vilify the movement, its aims and approaches as an enterprise. And it caused me to think, why at this point, 30 years after the formation of what has been an amazing contributing movement, intellectual framework and project in the scholarly dimension, are we still having these kinds of attacks? So I know Professor Thomas will speak more explicitly about the executive order of which I speak. So I'm actually going to spend my time exploring a disjuncture that I'm now finding a bit maddening and to ask what we might do about it. And that disjuncture is between CRT, which for a generation of students and scholars has been a lifeline for those who approach law but crave a different orientation to law, doctrine, power, and society, one that reflected their lived experiences, students who tended, and scholars who tended to be underrepresented, and first generation, who saw the doctrines in law as so foreign to them and inconsistent with the world they observed. For that group, CRT, including me as a young law student in the late 80s, really was a saving grace, something that made law school more understandable. It made law school more tolerable, if I'm honest. And it gave me a sense that all I knew was not somehow unworthy of being accounted for in the conversations that went on in law school. So I think it has been true that for a generation of students, CRT has been that singular connection point within law school that has saved us from what has been otherwise a particularly alienating experience and helped us see for ourselves or foresee for ourselves a space to operate within law where we could bring ourselves to the discipline and the profession, and really importantly, assist the communities which many of us cared about and came from. So on the one hand, there is CRT as this almost, necessary invention to preserve underrepresented law faculty and students. By contrast, what CRT is in certain circles reflected in the president's most recent executive order, which is a theoretical framework or movement that has been maligned by a set of scholars, jurists, political figures, criticizing its goals, theories, and methods, even as it misrepresented them, and to my mind, misunderstood them. And this was always surprising to me because as a student at Wisconsin, one of the things I did as a part of my project was trace the origins of CRT back to American legal realism and critical legal studies. Both were other movements that deconstructed law, challenging the claims and conventions of law for which there wasn't this significant backlash that lasted for the entirety of the movement. Those movements were allowed to carve out space of differential perspective without having their motives maligned, without having their scholars attacked, without having their theories or doctrines undermined. And so I almost chose not to say the names because it actually hurts to say them and you hate to give them any shine, but a group of scholars, including folks like Farber and Sherry, Ann Coughlin, Daniel Subotnick, jurists such as Judge Posner, wrote a series of both scholarly and popular media pieces which attacked and attempted to discredit CRT, claiming that it was little more than storytelling and possessed none of the traditional hallmarks of objectivity and neutrality expected from law. They often, reduced the conversation to insults rather than scholarly exchange, referring to CRT as the lunatic fringe and its scholars as radical multiculturalists. Some of the leading and founding members of CRT, such as Richard Delgado, Derek Bell, Kimberly Crenshaw, Charles Lawrence, Mari Matsud, and Pat Williams, were held up for ridicule and attack in ways that made no sense when one thought about the thoughtful, engaging, and really brave body of work they had put together in the early stages of CRT. And so this new flashpoint, sort of 30 years later, has caused me to ask, how is it possible that given all that has transpired between the late 80s and now, that CRT somehow remains notorious after all of this time, and that we continue to see the discourse or the so-called discourse really be nothing more than ill-considered attacks and name-calling, right? Which is the notion of CRT representing toxic approaches to diversity. Or I'll just quote this one little bit of language from the executive order as CRT spreads pernicious and false belief that America is an irredeemably racist and sexist country, right? And so there are so many ways at which one could take issue with that statement. But the point is, it doesn't actually at any point actually state what CRT is, what its goals are, what the tradition or trajectory of the movement is. It simply describes it as something that's dangerous and does so by maligning it. And so my point was to say, okay, clearly we have a disjuncture where CRT still remains very important to students and scholars, and somehow it still remains outside of the embrace of far too many folks for whom, if they actually learned anything about it, they would at least be called to enter a conversation or a discourse where they met CRT where it is, to challenge it based on its theories and its interventions, not based on some name calling of what it means to be a radical multiculturalist, whatever that is. And I actually thought about this moment in and around my own position now, where at my own school, my students continue to press me to add more CRT courses to our curriculum, to include courses that are mandatory in nature, to think about the way in which CRT is not just pedagogical or discursive, but actually belongs to what it means to create an inclusive environment for students whose lived experience is so distant from what is otherwise represented in law school. So I am constantly being called to expand our efforts here on behalf of students, to include more courses, to include more underrepresented students, to include more scholars, even as outside of law schools, we continue to see these attacks, the executive orders. We still have CRT scholars who talk about how difficult it is to be hired if your primary description of yourself is as a CRT scholar, and what it means to your tenuring. I did a tenure letter this year where someone who had done really good work had to go to deep lengths to describe for their own faculty in 2020 what it meant for them to do CRT work just so it could be treated hopefully with some level of legitimacy in their discussions of this person's tenure. And so the need for CRT still remains, the struggle to have CRT still remains. And one of the things that frustrates me at this point, not just the problem of not engaging with it and the way in which other movements, theories, and frameworks have been given credit, have been given at least the respect to engage with them in a discursive, thoughtful, and respectful way. But when you think about the product, when you think about the scholarship, what we have taken from CRT in those 30 years, and this is not an exhaustive list, but I just quickly thought through what are the important theories or interventions from CRT in my time, and the way in which race has become more thoughtfully described as a social and legal construction. The work on unconscious bias and the importance of introducing social cognition theories into law. Approaches to addressing discrimination that understand that you must think about racism as permanent in order to really address them fully. That the gains for minority populations are really not possible unless they also include some advantages for the majority interest. Y'all will recognize those as both Derek Bell theories. That the vestiges of whiteness are so powerful and permanent that they conceptually operate as a type of property interest. That modern forms of discrimination rarely reject all members of a suspect class, but rather reward or punish based on whether a person performs their identity in a manner that confirms with or rejects prevalent stereotypes, and that any discrimination analysis should embrace intersectional and anti-essentialist frames. If you think about just that tiny listing of those theoretical interventions, that is a canon of significance, of import, of intellectual heft, that has made contributions to law that are meaningful and have caused a whole generation of students to rethink about law, and law as a possible intervention, and law as complicit in arrangements that have led to discrimination and disadvantage. And so my sense is one of my problems is how do you have a conversation with foes for whom they never actually engage in a discourse that takes up a conversation about the theoretical and doctrinal interventions you advance, right? So part of the problem has been, and it's an oversimplification, but not by much, is most of what the attacks have done is either misrepresent what CRT is or simply name call. Your identity politicians, virulent identity politicians, and other kinds of framings that are helpful for stirring up a base of what you want is the race war, but not particularly helpful for understanding what CRT is and why it deserves a place at the table. So what I do is my project seeks to locate the source of this disconnect and to ask the question, what do we do if we care to do anything about it? I go through a number of things that I think contribute to the disconnect, but I'll break down what I think is the central problem here between CRT as a beloved kind of lifeline within law school and as a vilified, misunderstood theoretical frame outside. And it's that, how many minutes?
Dean Barnes, your time is up.
Okay, can I just make this last point?
Of course.
I just want to describe what I think. Okay, so for the students, scholars, and allies, what CRT has done is free frame connections between identity or self, law and system, and societal outcomes, which helps them to finally make sense of the disadvantaging arrangements that were for so long not named. But for the critics, the reframing calls out the explicit and implicit legal and systemic means through which advantage has been maintained. In so doing, CRT both challenges the commonplace notions of merits and deserts and renders those who fail to acknowledge the veracity of these claims as moral outliers. So in some way, the CRT can't be thought of as something legitimate, because to do so then would cause a great number of people to have to question some fundamental assumptions about their own status. And so I'll add some more of what I think we should do about this in the question and answer. But thank you for the time, and I look forward to listening to my colleagues.
Yes, what an amazing kickoff discussion. That was really wonderful and will really help to frame the remainder of our talks today. Now I have the pleasure of introducing Professor Tanya Hernández. Professor Hernández is the Archibald R. Murray Professor of Law at Fordham University School of Law. Her course array is prodigious. She teaches anti-discrimination law, comparative employment discrimination, critical race theory, the science of implicit bias in the law, and trusts and wills. Professor Hernández is an internationally recognized comparative race law expert and a Fulbright scholar. Today, she will present Latinos and Anti-Blackness. Professor Hernández, thank you so much for joining this panel.
Thank you so much for having me. It's a great honor. And I totally agree with Dean Barnes about critical race theory being life-saving. It has been for myself and it continues to be for my students. But let me get right to it so I don't waste any more of my 10 minutes. In considering the contemporary significance of critical race theory's trajectory, in light of the current racial context, I seek to draw upon the established tools of CRT in broadening its reach into the examination of how anti-Blackness is manifested in Latino communities and the legal deficiencies in addressing that. My research challenges the public presumption that the demographic growth of ethnicities other than African American means that anti-Black racism is a narrow issue that will decline with the growth of other racial identities. To the contrary, the growing proportion of Latinos does not determine the end of anti-Black racism as we know it. My objective is to aid those who care about the pursuit of racial equality by providing a more expansive view of the greater swath of the population that is harmed by anti-Black bias and how. By contributing the missing piece of Latino agency to an understanding of the complexities of racism, social justice actors will be better positioned to be more effective in an increasingly racially diverse world. This also serves as an invitation for critical race theory's continued nuanced examination of how communities of color can be complicit in the operation of US racism. So, straight to the point, Latinos can be racist, yet our national conversations about racism appear oblivious to this fact. Civil rights leaders are also seemingly reticent to air the dirty laundry of the bias that exists within communities of color, lest it distract from the real racism of white supremacy. However, all the while, Afro-Latinos and African Americans suffer from discrimination incidents at the hands of Latinos who claim that their racially mixed cultures immunize them somehow from being racist. I term this the Latino racial innocence cloak that veils Latino complicity in US racism. In turn, the public ignorance about Latino anti-Blackness undermines the ability to fully address the interwoven complexities of US racism. My research disrupts this status quo by excavating the otherwise silenced voices of the Afro-Latino and African-American victims of Latino anti-Blackness from the case files of discrimination charges. In examining how discrimination claims of Latino anti-Blackness arise, two central patterns become evident. First, Latino anti-Blackness is more prevalent and serious in its consequences than many commentators in politics and the media care to admit. Second, the ability to identify and address Latino anti-Blackness is hampered by the notion that Latinos cannot be prejudiced or racist simply by virtue of being Latino. It is for this reason that the tales of Latino anti-Black discrimination recounted in court cases are so important, inasmuch as they help to disrupt the Latino myth of racial innocence and clarify Latino agency in racism. The interrogation of the Latinos can't be prejudiced defense to racism is especially clarifying for the legal enforcement of anti-discrimination laws, educating both lawyers and judges about how Latinos are not only victims of discrimination, but also part of the problem of societal discrimination will fortify the ability of law to redress discrimination in an increasingly diverse society. It's not a cure-all, but it can certainly be part of the solution that CRT insights continue to eliminate. Let me give you an example from all the research that I've been doing. In the case of Maxine Sprott, it's very illustrative of the Latino anti-Black racial bride dynamic, wherein the performance of Latino whiteness entails subordinating Blackness against Afro-Latinos and African Americans as well. So let me tell you about Maxine. an African-American woman who worked as a deputy director of the New York City Housing Authority's Office of Equal Opportunity. And she alleged that her Latina supervisor and officer of the officer director, Rosalind Reyes, harassed her with derogatory comments about her work performance, despite the fact that Maxine repeatedly received positive performance evaluation, like good and very good. So Director Reyes insinuated that even though Maxine had attended several equal employment opportunity study courses at Cornell University, that she still didn't have a grasp of the nature of her work as it related to identifying and investigating cases of discrimination. Each positive performance evaluation rating that Maxine received was followed by commentary from the deputy director about Maxine's lack of leadership skills in her role. Even Maxine's proposal that the office purchase multimedia instructional material on sexual harassment was deemed by Director Reyes as an insufficient indicator of leadership initiative. Director Reyes also harassed Maxine about her timesheets and excluded her from various office functions and meetings. When Maxine could no longer withstand the onslaught of derogatory commentary about her competence, she filed a claim of discrimination with the general manager of NYCHA. Exactly 3 days after Maxine filed her claim, Director Reyes submitted a performance evaluation that for the first time rated Maxine as marginal, and as a result, she was denied a managerial merit salary increase. Any expectations that Maxine might have had that working for a city equal opportunity division focused on addressing discrimination in public housing would be a more racially enlightened workplace were shredded when her employer not only failed to investigate her allegations, but then retaliated against her for filing a claim. In fact, it was yet another Latino officer in NYCHA, Chairman Ruben Franco, that discriminatorily retaliated against Maxine. To be specific, when Maxine refused to accept NYCHA's proposed terms for settling her discrimination claim regarding Director Reyes, Chairman Franco informed Maxine that she was being transferred to another office where her material responsibilities were diminished, and she was moved from a well-furnished private office into a little cubicle. This was yet another instance of retaliation for Maxine's exercise of her right to assert her claim of discrimination. Only when Maxine filed suit in court was she able to reach a settlement agreement with NYCHA and receive financial compensation. Now, while any number of concerns may have influenced Maxine and her attorney to settle the case rather than to move forward with a jury trial, one contributing factor could very well have been the great significance the judge placed upon office racial diversity as mitigating claims of discrimination. For the judge, it was immaterial that when Chairman Franco transferred Maxine to an effectively lesser position in a cubicle at the same time as 2 other African-American female employees were being terminated, all part of Chairman Franco's ostensible reorganization plan. Instead, the judge concluded that such facts failed to raise an inference of discrimination because, quote, the new director is a Hispanic woman. There are now 2 deputy directors, one of whom is African-American. The remaining staff is comprised of 24 Hispanics, 23 African-Americans, 9 Caucasians, and 1 person categorized as other. The judge here accorded a diverse workplace, or what he viewed as diverse, and the supervisor's own Hispanic racial status as a power that could circumvent racism, without ever questioning what diversity actually means in our current demographic social order. Herein, then, is the judicial presumption that Latino coworkers and diverse workplaces cannot be bearers of racism. However, Latino anti-Black bias shows up not only as an expression of individual Latino racial attitudes, but also in systemic structures of intentional exclusion. So for instance, in 2016, Latino employees of a Chicago-based nationwide job placement agency described how their Latino supervisors trained them to exclude African-American applicants from job placements in favor of Latino applicants. They were instructed to automatically reject African-American applicants because of the stereotype that they were not capable of working as hard as Latinos. The lawsuit details how dispatchers who nevertheless sent African-American job seekers to a company would later be reprimanded by their Latino bosses for doing so.
Professor Hernández, your time is up.
Thank you very much. I will just.
You can add 1 sentence.
Okay. I will simply say that this is yet another example of how this is not only about individual discrimination, but there are also systemic ways in which Latinos are implicated in anti-Black bias, and that critical race theory is what helps us excavate this and better understand it. Thank you.
Awesome. Thank you so much. Very enlightening. Now, we are fortunate to hear Gloria Ladson-Billings, Professor Emerita and former Kellner Family Distinguished Chair in Urban Education at the University of Wisconsin-Madison. Professor Ladson-Billings is the current president of the National Academy of Education, a fellow in the American Academy of Arts and Sciences, and a fellow in the American Education Research Association. She is also the author and editor of 10 books, more than 100 journal articles and book chapters, and the holder of 8 honorary degrees from national and international universities. Professor Ladson-Billings will present Critical Race Theory Goes to School, an example of her pioneering work in the assessment of educational inequality through a critical race theory lens. Professor Billings, thank you for joining us. It is wonderful to see you.
Thank you, Professor Greene. I'm so glad to be here. I'm going to go to some slides so I can try to stay on time, and I've got a timer beside me because I know I'll ramble, and I also know that I'm the interloper here. I'm the person who is not the legal scholar. But I want to just kind of set a frame for the importance of race, law, and education and how they seem to work together. It's an interesting quote I came upon. Let me first get these slides going, I'm sorry. And I'll start with that iconic picture that we all know on the day that the court decided the Brown decision. But if we need to actually go back to the complicated history of Blacks and the law. This is a quote from an abolitionist minister by the name of William Goodell, who, in talking about Black people, and he uses the generic he says he's under the control of the law, though unprotected by the law, and can know law only as an enemy. And when I saw that quote, it made me think of this litany of people: George Floyd, Ahmaud Arbery, Breonna Taylor. They're under the authority of the law, but they're unprotected by it. And the law is indeed only known to them as an enemy. This long history of education, law, and race goes back to the Roberts case versus the city of Boston, where Mr. Roberts petitioned the city to allow his daughter to attend a school that she had to walk by to get to the, quote, Black school in 1849. He was unsuccessful in his petition, but it kind of sets the foundation or the groundwork for this attempt to access better education using the law. Of course, people know the Plessy case, which then sets this whole idea that separate is but equal is the law of the land. And this is the precedence that becomes the basis for maintaining separate schooling for Black students. I want to kind of run through the parallel and related routes to school desegregation and access. So there are some K-12 cases of note, and there are some post-secondary cases of note. And while they are at different levels, there is a relationship between both types of cases here. Case that people don't talk very much about is Alvarez versus the Lemongrove School District that happened in Southern California, where these migrant students were taken from their school, told that they had to go to a separate school. And they brought the case in the California courts where they were actually permitted to go back to the original school because they were deemed white. Now, if you go back and look at the census, from 1790 to the 2020 census, you will see that that question about race has been asked a lot. And in 1790, Mexican Americans came under the category of white. The judge actually said, had they been Indians or, quote, Negroes, then the school district would have prevailed. So it is this whiteness that Mexican Americans are able to appropriate that let them go back to the school. However, when you get to 1947, Menendez v. Westminster, the Mexican American students were being segregated because of their language. And because Gonzalo Mendez made such a big fuss over it, the district decided, oh, well, we'll let you and your kids come. But because they were Puerto Rican and not Mexican American, and Gonzalo refused, finally, the judge ruled that the Mexican American students would be served better in the schooling environment where they would be exposed to the English. So in the Lemongrove case, it's about them being white. In this case, it's about them being better served by learning to speak English. We jump over to some of the cases that were litigated on the collegiate side. We have the infamous Sweat v. Painter in 1950, where Herman Sweat was denied admission to the University of Texas Austin Law School because the issue was there was no separate school. And so while the case was in mandamus, the state was building a separate law school at Texas Southern because they really didn't want Mr. Sweat to be able to attend the UT Austin school. Similarly, in Oklahoma, McLaren was attempting to go to school and to get a master's degree at Oklahoma. And this picture is sort of iconic because they tried to build separate physical barriers. Mr. McLaren had a special place in the library he was supposed to sit. He had a special place in the cafeteria, and he's literally kind of in a box in the classroom because they did not want him to be in direct contact with his white classmates. But the iconic case, of course, is the Brown case. And Brown, of course, is more than one case. It is a set of cases. The Belton v. Gebhardt, the Beulah v. Gebhardt, the Briggs v. Elliott, and Bowling v. Sharp, and the Davis v. County School Board of Prince Edward. Now, what I think is interesting about some of these early cases is they really weren't trying to integrate schools. They were trying to ensure that they could get transportation to the segregated schools they were being sent to, but they all got rolled up into the Brown case. While Brown is iconic, and in fact, we just had a Supreme Court nominee claim Brown was settled law, and it's one of the ones that all justices, my dean at the School of Education, has interviewed every Supreme Court justice some years ago and asked, what are the cases that all school children in the civics class must learn? And the two cases they all agree on are Marbury versus Madison and Brown. So Brown becomes this really iconic case, but what we don't talk about is the systematic rollback of Brown. In San Antonio v. Rodriguez, that doesn't allow for equal funding. In Milliken v. Bradley, that doesn't allow for using suburban districts to integrate. In Oklahoma v. Dow and Freeman v. Pitts, all of these cases constantly chip away at what Brown is supposed to mean, till we get to a place where we turn Brown upside down in the Parents Involved Community Schools versus Seattle, in which white families petition the court because they want to get into a specialty high school. And they win this case. This case is also linked to a case in Louisville. But back on the college front, we have to also remember what happened with the Regents of the University of California versus Awaki, where the court says that race can be a consideration. Awaki, of course, was trying to get into UC Davis to go to med school and claimed that his scores were better than some of his Black counterparts. And then the Michigan case has become half a loaf, where they don't prevail at the undergraduate, but they do prevail at the professional school, at the law school level.
Professor Billings, could you just take a minute or so to sum up?
Oh yeah, okay. So I will just quickly say we're still looking at what I would call the slim victories of Fisher, which probably will come back, and the question of whether or not we are litigating our way, trying to litigate our way to equity. I was expert witness on these Abbeville cases in South Carolina. And then I had the nerve to ask an outrageous question in the University of North Carolina Law Review, in which I said, can we at least have Plessy? I will just finish by suggesting that we have to look at what lies ahead. We know the students for fair admissions versus Harvard is ahead, the expansion of charter schools are ahead, and expansion of voucher programs. So that's sort of the broad view of the ongoing relationship between school, law, and race.
Fantastic. Thank you so much. Back to Plessy. Better than half a loaf.
Yeah.
Elaborate on that.
A real Plessy versus a fake Brown.
You have to elaborate on that in the Q&A. Thank you so much for joining us. Well, next, I am very pleased to introduce Angelica Guevara, the current Hastie Fellow here at the University of Wisconsin Law School. Dr. Guevara's work centers on the rights of the disabled in higher education. As a neurodivergent Latina herself, she encountered countless obstacles when requesting her disability accommodations in the course of obtaining her BA from the University of California at Los Angeles, her JD from the University of California, Berkeley Law, and her PhD from the University of California, Berkeley Graduate School of Education. In the course of her amazing journey, she learned that as a result of stigma and stereotype, educators have very low expectations for people with disabilities. These low expectations make it difficult for people with disabilities to obtain the accommodations necessary for the full development of their potential during their higher education experience. Dr. Guevara's paper is entitled "The Need to Reimagine Disability Rights Law Because the Medical Model Fails Us All." Dr. Guevara, we are so excited to hear about your work. Thank you for joining us.
Thank you very much. I'm so excited to be here, and it's really an honor to be amongst amazing people. I'm going to go ahead and share my screen, PowerPoint, and I'm going to try to keep it to 9 minutes. There we go. So my focus is on the need to reimagine disability rights law because the medical model of disability fails us all. It's very important that I state that it's a two-part project. The current paper that I am working on first establishes that current disability anti-discrimination law operates under a medical model of disability. The next paper will get into the details as to what the law would look like under the social model of disability. So just a little roadmap of what I'm going to be presenting. I'm going to describe the premise of my work, or essentially tell you the premise of my work. I'm going to describe the models of disability. I'm going to talk about the pandemic, and I'm going to present the 7 tenets of disability studies and critical race theory, known as DISCRIT, and talk about investing in our future. So my starting premise of all my work is that all human beings are born free and equal in dignity and in rights. I obviously get this from the Universal Declaration of Human Rights, Article 1. I try to counter the narrative of current disability, counter the stereotypes by presenting stories. For brevity, I didn't include a story of an individual that doesn't have any arms or any legs. And if you were to look at him and think that he cannot swim, you're disabling him because he in fact can swim. But instead I wanted to focus on stories that have apparent disabilities and non-apparent disabilities. And here we have Helen Keller to our left, who was deaf and blind, who eventually went on to become a professor, and Haben Girma, who was also deaf and blind and graduated from Harvard Law. Stories of non-apparent disabilities that I don't know if you might know about, but Abraham Lincoln actually was very severely depressed when making some of the biggest decisions in our nation's history. He was taking mercury pills, and we know that mercury is a neurotoxin. And Dr. Temple Grandin, who has autism, she designed a system for livestock in order to be able to clean them and shower them so that they're not in a stressed condition and not releasing those stress hormones in our food. There are two ideological camps in disability, and that is, the first one, it's better to increase the pie before you divvy up the pie, an excuse for those who do not want to invest in the severely disabled, and I put that in quotes, and my camp, which is just distribute the pie equally in terms of resources. The medical model, essentially, doctors are the ones that determine whether an individual has an impairment or a loss of function. An impairment, an illness, is a purely medical phenomenon. Disability is a social construct. Sometimes individuals with disability end up internalizing those feelings of impairment. The medical model of disability basically states it's a personal tragedy, which suggests that a disability is some terrible chance event that occurs at random to unfortunate individuals. It views the individual with pity as defective or having an impairment that must be eliminated or cured. The critique of the medical model is that it fixates the problem within the individual while simultaneously absolving society from any further consideration. It perpetuates stereotypes, perceiving people with disabilities as not whole or damaged and in need of fixing. The social model, on the other hand, empowers people with disabilities. Unlike the medical model, it puts forth the idea that society disables individuals. The structures of our society creates disability. There is nothing deficient or wrong with an individual with a disability because there are diverse ways of existing in the world. So just to give you an example of different ideologies that are out there, in terms of like the social model of disability, the Anangu people in Australia don't have a concept of disability. The Mixtec people in the southern part of Mexico, they only value what the individual can contribute to society, especially for those that have intellectual disabilities. An example of the medical model, essentially manufacturing disability and how an individual can be disabled by a society, is the example of Alan Turing. He helped break the German Enigma code and pave the way for artificial intelligence theories. Back in the 1950s, gay was considered a psychiatric disorder, and society essentially disabled him by not fully embracing him and chemically castrating him. And in turn, he ended up becoming severely depressed and committing suicide. So my work tracks the evolution of the Disability Anti-Discrimination Law, but it tracks it from the Vocational Rehabilitation Act of 1980, and it follows the language that then transpired into the Labor Law of 1938, specifically Section 14C, where they allowed employers to pay people with disabilities less than the federal minimum wage. I then talk about anti-discrimination law, which is the ADA and 504. I go into case law in action and how the law ends up failing us all. With the pandemic, it affected us all. Working from home, the COVID-19 stigma, oh, do you have it? Did your parent have it? So that is something that we all experience, the loss of loved ones, the loss of a home, the loss of a job, the thing that ended up creating the post-traumatic stress during the pandemic, depression, anxiety, you're not able to socialize. And so when individuals try to access anti-discrimination law, it's ineffective. And they're experiencing something that we have already experienced in disability, that the law is ineffective in terms of ADA and Section 504. So that's why we need to move towards a social model of disability in the law. Unfortunately, the pandemic disproportionately impacted people of color. People of color at higher rates lived in crowded housing conditions. They work in essential fields, have inconsistent access to healthcare. They suffer from chronic health conditions. They have higher levels of stress due to income inequality and institutionalized racism, which compromises their immunity. So that's one of the reasons why I bring in Discrit. And I try to do an analysis with the 7 tenets of Discrit. The tenets basically acknowledge that racism and ableism uphold notions of normalcy. It values multidimensional identities. It acknowledges that whiteness and ableism is socially constructed. It privileges the voices of the marginalized. So nothing about us without us. If you're going to create a law, include us that affects us. Acknowledges the legal and historical aspects of disability and race. And for a recent paper that I just wrote, essentially it acknowledges that whiteness and ableness are property. It supports activism and forms of resistance, and so moving towards the need to have discrit. Now, since this impacts us all, I posit that if we use the social model of disability, you may see an increase in inventions because people wouldn't be ashamed to come out of the disability closet because there would be no disability closet to begin with. So here I have just some examples. I have the iRobot home robot vacuum. You don't have to have a disability to be able to utilize that. The kangaroo electric car, there's an individual with a wheelchair can wheel himself in from the back and start driving. The iBot stair climbing chair, it actually climbs stairs. The Lucy 4 keyboard, with your eye, you can go ahead and type in the letters and it comes out in the computer. Finally, we have the smart belt, which can detect seizures before they happen, and the Braille smartphone. And that essentially is my presentation and how I incorporate critical race theory into my work. Thank you so much.
Thank you so much. That was very illuminating, and we'll look forward to more discussion when all our other panelists have spoken. Next, we have the multi-talented Professor Kendall Thomas of Columbia University Law School, who is an accomplished musician, vocalist, performance artist, as well as the Nash Professor of Law at Columbia University Law School. Professor Thomas is the co-founder and director of the Center for the Study of Law and Culture at Columbia University. He was an influential intellectual leader during the 1989 Wisconsin Critical Race Theory Conference. In addition to his publications in academic journals and in scholarly and popular anthologies, Professor Thomas is an editor of Critical Race Theory, Key Writings That Formed the Movement, 1995, the first anthology of critical race theory. His 2005 collaboration with choreographer William Forsythe, Human Rights, has been performed to critical acclaim before audiences in several venues, including the International Theater Festival in Istanbul, Turkey, and at the invitation of the United Nations Office of the High Commissioner for Human Rights in the Palais des Nations in Geneva, Switzerland. The title of his talk is Critical Race Theory and the Weaponization of Racial Illiteracy, in which he draws on interdisciplinary critical analyses of race, representation, and cultural politics to offer an account of the recent attack on critical race theory by the Trump administration and its allies. Welcome, Professor Thomas. It's wonderful to see you, and we look forward to hearing you.
Thank you, Professor Greene. It's a delight.
Professor Thomas, I'm very sorry to interrupt you. We do need to make a brief CLE announcement. We'll have to announce the first passcode, and then we'll be happy to have you start. So I'll do that now. The first passcode is law. I'll be sharing my screen. That's LAW. So if you're a Wisconsin attorney looking for CLE credit, you can find that here. Please email me with any questions. The first passcode is law. I apologize for that interruption. Professor Thomas, please continue.
That's quite all right. I hope that I haven't lost my time as a result of that announcement.
Oh,
we don't have much, so I'm going to cut right to the chase and go to a PowerPoint presentation, which I hope you can all see. Do you see it? No. All right. Well, you know what? Let's forget about the PowerPoint presentation. It's a great pleasure to be here, and Professor Greene has already told you what the title of my talk is. And so the paper tries to do three things. The first is to offer what I call a pedagogical reading of the executive order on combating race and sex stereotyping that was issued by the Trump administration just last month in September 2020. I interpret this effort as an executive branch attempt to purge and extinguish critical race theory. These are the president's own terms, purge and extinguish. I see it as a kind of national civic seminar whose chief tactical tool is a weaponization of the American public's racial illiteracy. The second task is I try to trace the connections between the White House's crusade against CRT and 19th century state statutes outlawing the education of enslaved African Americans on one hand, and its coincidence with 21st century African American led campaigns for recognition of a constitutional right to literacy on the other. And third and finally, I try to show why we must move beyond the dominant discourse of anti-discrimination and diversity if we want to understand what Mr. Trump's weaponization of racial illiteracy means and what it's doing. So that's the goal of the paper that I'm writing for the symposium issue of the Wisconsin Law Review. Now, I can't possibly, in the 7 or so minutes left to me, talk about all three of those things. So I'm just going to try to answer one question. And that question is, why weaponization? As Professor Greene noted, I was one of the 4 co-editors of the first anthology of collected writing on critical race theory, to which Professor Greene was a contributor. And as I've watched the president's attack on critical race theory, not just through the executive order, but through tweets and through conversations with his surrogates on Fox, articles in Breitbart, etc., I have been struck, like Professor Barnes, by how unrecognizable the thing that they're describing using these 3 words, critical race theory, is to me, and how little connection it bears, in fact, to the work I do or the work that I've done in collaboration with others. So the weaponization begins really through misrepresentation, right? They don't misunderstand critical race theory. I'm pretty sure that the president has never read anything by critical race theorists or ever talked to a critical race theorist. That's not the point. The weaponization of critical race theory then is really, in some respects, like the weaponization in France and in South America of gender theory, as its opponents called it, which was something the right made up in France and in South America to discredit the struggles of women, of people of color, and of LGBTQ people for rights and justice. So we ought not fool ourselves or fall into the trap of thinking that what's going on today bears any relationship whatsoever to the kinds of debates that were going on in the pages of law journals, in national journals and magazines in the 90s about critical race theory. This is something different, new, and decidedly more pernicious. So that's the first point I want to make. The second point I want to make is that my critique is what the Frankfurt School of the 1940s and 50s would call an imminent critique, which is to say, I'm not taking this word weaponization out of thin air. It's the word that they themselves are using. So I'm going to read a little bit from the very long article that I've been working on for the Law Review. So Christopher Rufo, a commentator, filmmaker, and writer, expressed his absolute astonishment in an interview with Tucker Carlson on Fox News that critical race theory, quote, has come to pervade every institution in the federal government. Rufo went on to say, quote, what I've discovered is that critical race theory has become, in essence, the default ideology of the federal bureaucracy and is now being weaponized against the American people, is now being weaponized against the American people. Now, 25 years ago, in our introduction to the critical race theory volume, we advanced the thesis that, quote, scholarship, the formal identification, production, and distribution of what will be called knowledge, is inevitably political. And we went on to say that each of the scholars who contributed to our book sought, quote, not simply to explicate, but also to intervene in the ideological contestation of race in America and to create new oppositionist accounts of race. We, in other words, were part of a shared effort to increase and advance critical racial literacy, right? And so I think what's most important about this recent development is the way that, in fact, it is weaponizing the illiteracy around race that is characteristic of so much of our national discourse, and which in many ways has become, in the post-civil rights movement, the cornerstone of white racial identity, right, in the United States. So as I said earlier, one of the things I find most fascinating about the Trump administration's weaponization of critical race theory is its aggressive and active misrepresentation of critical race theory. In the executive order that I'll be talking about at greater length in my article, in the president's many tweets in which he called CRT a sickness that cannot be allowed to continue, and which, if one sees any sightings of, they should report, presumably to the Trump administration, so that, in the president's words, we can quickly extinguish them, right? So it's as though critical race theory has gone viral, infecting not just the federal bureaucracy, but perhaps the very nation itself. So this weaponization of critical literacy to secure and to consolidate racial illiteracy is what I think is one of the most distinctive aspects of what the Trump administration is doing. And the second most distinctive aspect of what the Trump administration is doing is that the state is doing it, right? This is a mobilization of state power. And it's buying into a narrative, I don't have time to really go into it, that I found in the media conversations, which links critical race theory not just to the protests that are occurring, but to violence, right? And we know where that leads, right? The representation of critical race theory as advocacy of violence justifies a violent response to critical race theory and critical race theorists, right? So there's a necropolitical dimension here of racial violence that we ought not ignore. And there's a lot more to be said about the connections between this weaponization of illiteracy and the long history in which the law and state power have been used to maintain a regime of what I call in my paper compulsory racial illiteracy. But I don't have time to go into that. So I will just finish because I'm fairly certain that I don't have too much more time. Our late friend and mentor, Professor Derek Bell, wrote in 1980 a path-breaking article that was published in the Harvard Law Review called Brown versus Board of Education and the Interest Convergence Dilemma, in which he argued that any advances Black people and other people of color have been able to make in this country have been a consequence not of high moral principle or deep commitment to democratic justice, but a convergence of the interests of whites and Blacks. We are, interestingly, at a moment in which the convergence of the interests between white elites and Black elites on which Bell focused in Brown has been replaced in our age of inequality by divergence of interests between a multicultural elite and the Black, brown, and white poor who are being equally mis- and undereducated by an increasingly carceral public school system. For me, one of the principal stumbling blocks to a recognition of the linked fates of poor and working class Americans of color and white poor and working class Americans is our racial illiteracy. The compulsory character of racial illiteracy in America, which I want to show on the paper is a continuing thread, can be seen in the energy and effort the current administration is expending to demean and quite literally denigrate or blacken, associate with Blackness, the calls for national conversations in the United States about slavery and its aftermath. And again, I say this fully mindful of the fact that there's a twin prohibition in the executive order that I haven't had a chance to talk about of race and sex. The executive order, the tweets, the speeches, the memoranda, and other texts and images alongside which the order must be read are, to use Omi and Wynant's well-known term, a racial project. The purpose of that racial project is to mobilize the force and will of the federal government's power to purge the US state of critical racial language and literacy. Purge is the president's own term. In a prophetic meditation published the same year as our 1995 Critical Race Theory anthology, the late Toni Morrison insists that we cannot take the full measure or grasp the full meaning of contemporary racial projects without attending to racism's succubus twin, fascism. Fascism, Morrison argued, its hallmark, the thing that makes it recognizable, she says, is its need to purge. By way of a conclusion then, I want to suggest that the purgative power unleashed by the current administration against critical race theory, or what it calls critical race theory, unleashed, I want to argue, against racial literacy, can indeed be understood only if we are willing to see it as an example of how fascism works, to use the title of the recent book by Jason Stanley. Stanley contends that the right represents, quote, its own desire to control acceptable lines of inquiry by tactically advancing its attack on institutions and individuals, institutions like universities and individuals like intellectuals who, quote, stand up for public reason and open debate. But they do so, the right, under the cloak of protecting those very ideals. In my paper, I hope to show that contests about critical racial literacy and the attempt politically to maintain racial illiteracy will likely remain central not only to the continuing struggle for racial justice in this nation, but indeed to the ongoing battle over the meaning of America itself. Thank you.
Thank you so much. Thank you. Wonderful. Interesting connections, Professor Thomas, between your concern about racial literacy and also Dr. Gloria Ladson-Billings' work in the area of education. So perhaps we can talk more about that when at the end. And now we have Angela Awaki-Willig, Dean and Professor of Law at Boston University Law School. She earned her JD at the University of Michigan Law School, and from Yale earned 1, a Master of Arts, 2, Masters of Philosophy, and 3, her PhD in Sociology and American Studies. Before she became Dean, she was previously the Chancellor's Professor of Law at the University of California, Berkeley. And before Berkeley, she was the Charles and Marion Kirsch Professor at the University of Iowa College of Law. She is the author of According to Our Hearts, Rhinelander versus Rhinelander and the Law of the Multiracial Family, and numerous articles in leading law journals. She served as chair of the AALS Minority Group Section, chair of the AALS Law and Humanities Section, and the AALS Employment Discrimination Section. She's a recipient of numerous teaching awards, a former Iowa Supreme Court finalist, and an elected member of the American Law Institute. In 2018, she won the Law and Society John Hope Franklin Jr. Prize for her article, Policing the Boundaries of Whiteness, the Tragedy of Being Out of Place from Emmett Till to Trayvon Martin. The title of her talk is #CRT, How Critical Race Theory and Technology Enables Today's Social Movement for Racial Equality. In this paper, she discusses how today's protests and their successes have been facilitated by the development of social media and the teaching of critical race theory to millennials in classrooms across the country. Thank you so much for being here today, Dean Onwuachi-Willig.
Thank you. First, I want to thank Professor Greene not only for organizing this panel and for inviting me to be a part of it. I feel very honored to be a part of this illustrious panel, but also for really being on the ground and being a part of the group that had the first critical race theory workshop and meeting at Wisconsin in 1989, along with people like the late Professor Bell and of course my co-panelist, Professor Thomas. And I also want to thank the Wisconsin Law Review editors. In particular, I want to thank Abigail Chase and Connor Clegg for all their hard work on this symposium and the panels. Thank you very much for that. So I want to discuss very briefly, how CRT is at the foundation of the most prominent social movements we see today, from the resurgence of the Me Too movement founded by a Black woman, Tarana Burke, to Black Lives Matter, which is founded by 3 Black women, 2 of whom identify as queer, Opal Tometi, Alicia Garza, and Patrisse Cullors. So really contrary to what many critics of CRT have argued, except for our current president, who has actually expressed concerns about the actual impact and effect of CRT, CRT has, I believe, shaped both legal and social policy and social and political movements, and in particular over the last 10 years, and I'll explain why I think that. In fact, critical race theorists themselves have defined CRT as a scholarly movement, one that makes theoretical interventions regarding the relationship between race, racism, and the law, and also that has encouraged and in fact inspired and guided action and social movements. So this summer's protest actually provides some insights. The murder of George Floyd by Officer Derek Chauvin in Minneapolis ignited large protests across the globe. It's led by millennials. They're the second most racially and ethnically diverse generation in the history of the United States, second only to Generation Z, which is the youngest generation. And their protests have been called the multicultural movement that's making history. And as my colleague, Professor Karen Petalora would tell you, this summer's protests are our largest protests, right? With a flood of protesters demanding racial justice that surpasses the numbers from the civil rights movement of the 1950s and 60s. And she'll also say that today's activists look different than those of the past, who were overwhelmingly people of color, that whites actually now comprise the largest group of today's protesters. So looking at the protests of 2020, we see that leaders of the current social movement for racial equality have drawn some of their strategies and tactics from the playbooks of the civil rights movement of the 1950s and 60s. But as many have proclaimed, today's protests, they feel different. Not only are the protesters a rainbow coalition of races and economic groups, they seem to be achieving reforms that once seemed unimaginable, like the protesters of the 1950s and 60s. And scholars are asking why. What forces have enabled these protests to emerge and take effect? And the project that I'm working on with Nia Johnson, a 2019 graduate of BU Law, and now a PhD student in health policy at Harvard University, we're looking at how today's protests and their successes have been facilitated in large part by a combination of 2 factors. Number one, the emergence of CRT, right? The teaching of CRT to a generation that has grown up in a world in which CRT has always existed, and the development of social media and its impact on the resource mobilization component of social movement making. So in my brief talk, I want to briefly highlight sort of social movement theory a little bit, sort of the informal and formal means to which people form social movements. I want to briefly talk about how CRT has played a meaningful role in shaping those movements, and then finally talk about how the emerging social media has helped to create new avenues for those who did not have access to power to traditional media networks to mobilize their social movements previously, but now have access to those because of social media. So traditional models, early models of social movement theory focus on movements as products of grievances or social strain. They generally viewed it as a psychological process where social conditions affected individuals and motivated them to challenge the status quo. So as Matthew Huey has explained, early scholarship on social movements posited that social movements were emotionally charged, unorganized, spontaneous, and disruptive behavior that was incongruent with institutional and organizational order. But if you look at more recent social movement theory, it's centered on three theoretical perspectives: mobilizing structures, political opportunities, and framing. And these approaches, one could say, are the sort of the how, the where, and the why of social movement theory. And we're really focusing on the how and the why. The first approach or the paradigm, our first approach is mobilizing structures theory, addresses the how of social movements. It looks at the formal and informal vehicles through which individuals may form social movements. And there are a couple of branches, and we're focusing on resource mobilization here. And the resource mobilization theory focuses on the role of formal organizations in developing social movements. It centers on the formation of social movements formed by professional organizations. And the second branch, the political process model, focuses on informal grassroots mobilizing structures, such as the role of local Black churches in the civil rights movement. And then the second approach is really sort of the where of social movement theory, which sort of looks at institutionalized political structures. I'll skip over that a little bit. And then finally, the third approach or theoretical perspective is the framing theory, which centers on the why of social movement creation and development. It focuses on shared meanings and definitions that people bring to their situation, and the more cognitive or the more cognitive dimensions of collective action. And here's where CRT, we say, comes in as well. So if we look at we just look at one, and we'll focus on Black Lives Matter, probably the most prominent social movement of our time, we can see how CRT is laced throughout that particular movement. At its core, Black Lives Matter centers on the notion that our understandings of race and race people are socially constructed, that different groups are racialized in different ways, that colorblind approaches are not an effective means for dismantling subordination, and relatedly, that constructing strategies based on converging interests is not a way to, as Paul Butler would say, Professor Paul Butler would say, to get free. And then finally, that stories matter. So for instance, rather than organizing under a race-neutral moniker or a moniker that referred to all people of color, the founders, right, the founders I noted before, opted to embrace rhetoric that speaks to the disparate treatment felt, particularly and uniquely by Blacks in the United States. Their movement communicates the reality that Black lives in particular are framed as dangerous and deviant in ways that have led officers, that have led civilians to quickly associate Blackness to criminality and to more quickly view a Black person's actions as hostile and thus deserving of excessive force, like shooting and killing. So Black Lives Matter's movement's endorsement of an anti-colorblind approach is most evident in its responses to resistors who insist on asserting that, quote, all lives matter, end quote. Through protests and interruptions at events like gatherings, a variety of gatherings, Black Lives Matter's protesters have educated the public about the damaging effect of pretending that all individuals, regardless of race, face the same hostilities. As Alicia Garza once explained, quote, we perpetuate a level of white supremacist domination by reproducing a tired trope that we are all the same rather than acknowledging the non-Black benefit from anti-Black racism. When you drop Black from the equation of whose lives matter and then fail to acknowledge it came from somewhere, you further a legacy of erasing Black lives and Black contributions from our movement legacy. And at the same time, they're not saying that Black lives matter. It doesn't mean that Black lives are more important, but it just means that, again, as I said, racialized groups are racialized differently and they have different experiences. Furthermore, Black Lives Matter's insistence that voices of color not be silenced or hidden or subdued in any way rests on the notion of a unique voice of color, in this case, a unique voice of Blacks. The movement welcomes allies of all races, but expresses the need for those allies to investigate and to examine how anti-Black racism is perpetuated, furthered, and emboldened within their individual communities. So they're always asking their allies, you need to engage and reflect on yourselves, and you need to challenge people in your own communities as well. And additionally, Black Lives Matter represents a very interesting example of interest convergence in social activism. Rhetorically, they refute interest convergence as a means of achieving progress, and it's purposeful. Black Lives Matter calls upon members of the dominant group to enhance the lives of Black citizens for no other reason than because Black citizens matter too. There's no focus on reframing the argument that Black lives matter in a way that would appeal best to whites. On its face, Black Lives Matter does not appeal to the interests of the majority. However, the movement, certainly aware of the power of interest convergence, has articulated how ensuring that all Black lives are equally valued can be a benefit to all people, not just to Black people. And one of the mantras of the Black Lives Matter movement is that when Black people are free, quote, when Black people are free, everybody gets free. The argument is, quote, quote, hashtag Black Lives Matter doesn't mean your life isn't important. It means that Black lives, which are seen as without value within white supremacy, are important to your liberation. Given the disproportionate impact state violence has on Black lives, we understand that when Black people in this country get free, the benefits will be wide-reaching and transformative for society as a whole. When we are able to end hypercriminalization and sexualization of Black people and end the poverty control and the surveillance of Black people, every single person in this world has a better shot at getting and staying free. And some, even though Black Lives Matter has rejected interest convergence as a means of accomplishing their legislative agenda by refusing to reframe its arguments in a way that could diminish the focus on Black lives, it has also embraced interest convergence, this notion that minority gains occur only when interests converge with those of the white elite as a means of conveying how equality for Black people can mean equality for all. In addition, projects like the Black Lives Matter project, I imagine, have incorporated the strength of storytelling that critical race theorists have been touting since its beginning. The I Imagine project asked people to submit audio responses of their visions of what life would look like in a world where Black lives mattered. By relying upon personal narratives and audio clips of real people, Black Lives Matter has engaged in the project of rewriting stock narratives of the Black experience and has instead offered counter stories, countering stereotypes through personal storytelling. Counter narratives are critical because they are one of the main ways that implicit and explicit biases can be reduced. And in fact, Black Lives Matter has explicitly stated that art is key in helping us imagine a new vision for the world. Quote, "We need to change the narrative, y'all, and art helps us do that," end quote. So these types of retellings have also become a staple of Black Twitter, which is part of the movement as well, which one could argue is which went to a very important extension actually of the movement. Over and over, Black Twitter has highlighted the privilege rooted in the different treatments of Black and white victims. So consider the Twitter campaign, again, another different kind of storytelling, hashtag if they gunned me down. This Twitter campaign offered a sharp and persuasive critique of the ways in which Black victims get demonized in the media through chosen representations of their character. In this critique, Black tweeters posted two contrasting pictures of themselves, suggesting with their posting the more sympathetic photograph, maybe one from their graduation or a military ceremony or church scene, would be the photograph that the media would choose to ignore and would instead choose to publish a more racially stereotypical or negative image, an image that provided only one limited snapshot of their lives.
Onwuachi, I think you will have to sum up. It's very exciting. We have to leave time for the
So
Q&A.
I would just say also too that intersectionality, of course, is at the center of it. Even though Black Lives Matter was founded by 3 Black women, 2 of whom were queer, one of the struggles has been that the stories of men have sort of emerged, and that has been a constant critique of the movement as well. One of the interesting things about the movement as well is that the way social media has really changed the way that movements form. It used to be that you needed to have a gatekeeper, like a major news story, a major news station or a major newspaper pick up your story so that you could have a movement take off. But social media really changes it, right? If something goes viral, the news channels, the newspapers often may have to follow the stories. And we saw this with Trayvon Martin. We saw this with, of course, Michael Brown. We saw this, we could sort of follow this, right? Where the people were able to create the story. And so it sort of changes the way that resource mobilization has functioned in the past.
Fantastic. Thank you. Oh, it gives me no pleasure to stop you from speaking. Ms. Chase, I was just going to close and then turn over just a couple of words and close and turn the Q&A over to you. Is that what you
Yes.
like?
Yes, that would be great. If you would like to close, we're actually going to do the CLE announcement prior to the Q&A, so people can stay a little later as long as all of our panelists are okay with that. We can go a little bit past 6:30 if that's all right with you all.
Sure, that's great. Just 2 sentences. When I proposed this panel, I wanted to share with my beloved community here the ideas of these amazing scholars who have reshaped legal theory and educational theory. I had hoped that not only would they be able to show the deep roots of critical race theory and its connection to the University of Wisconsin Law School, but that they would also be able to show how relevant critical race theory is to today's movements for social justice and racial justice and justice for all people. And my dream has been realized. I won't talk any longer except to say I am truly blessed to have had the opportunity to be a part of this panel with all of you. And I'm going to turn the floor over to Ms. Chase and Mr. Clegg to orchestrate the Q&A. I don't know how many questions you have, but if there is an opportunity for the panelists to elaborate after you've had the questions, I'll let you just manage that if you want.